Hello and welcome to the Sidebar, presented by True Crime News, taking you inside the courtrooms of high-profile and notorious cases from across the country. I'm your host, Joshua Ritter. I'm a criminal defense lawyer based in Los Angeles and previously an LA County prosecutor for a decade. You can find me on all social media at Joshua Ritter ESQ or at joshuaritter.com. We're recording this on Wednesday, December 4th, 2024. In this week's episode, a judge shuts down the Commonwealth's request for evidence ahead of Karen Read's retrial for the death of her Boston police officer boyfriend. Plus, convicted mother Jennifer Crumbley's latest appeal to have her conviction overturned for her role in her son's mass school shooting. But first, a woman is arrested following her son's unaccompanied walk to a local store, raising new questions about the responsibilities of parents. Today, we're joined by Lara Yeretsian, a criminal defense attorney and nationally recognized legal analyst that you can catch on Court TV, News Nation, and many other outlets. Lara, welcome.
It's a pleasure to be on with you.
Thank you so much. I've been looking forward to this because we talked about this a little bit before we got on camera here, that you and I have both worked in Los Angeles for a couple of decades now in the criminal world, whether it was I was on the DA side of things or criminal defense side of things, and we've never actually run into each other in court, which is strange, but we've seen each other a couple of times on TV commenting on the same case. So I'm glad that we had an opportunity to finally get together to do this.
Agreed. I was looking forward to this one.
Oh, good.
Maybe soon we can plan on, maybe hopefully we'll have a case together. Or
yeah, you let me know. Next time you need help with a co-defendant, you give me a call.
You got it.
Well, let's jump right in. Some really interesting cases this week. First, out of Fannin County, Georgia, a mother's arrest on a charge of reckless conduct ignited a national debate on childhood independence and adult supervision. Brittany Patterson was handcuffed by authorities in front of her children after her 10-year-old son walked to a local store unaccompanied. While Patterson took one of her older children to the doctor, the boy walked himself to the Dollar General store less than a mile away from the family residence when a concerned neighbor called police. Patterson's arrest understandably led to a conversation about free-range parenting, with some commending the mother for trusting her children, while a warrant claimed she, quote, willingly and knowingly endangered her juvenile son's bodily safety. Following the incident, the mother of four declined to sign a quote-unquote safety plan proposed by DFCS, which included placing a GPS tracking app on her son's phone. Patterson's lawyer told outlets that her refusal to sign the plan is tied to her belief that she hasn't done anything wrong. Lara, jump right in. I'm curious to just get your hot take on this. What is your reaction to this case?
My initial reaction is, as a parent, how scary is that? You get arrested in front of your children just because the child walked to a gas station. I mean, typically that's not where you see these types of cases or charges filed. Look, we can all agree or disagree on whether a child should be left alone and allowed to walk less than a mile to a gas station. You know, different parents have different opinions, but that has to do with parenting, right? For them to get from a parent and there's also the realities of being a parent, where one child is sick, you don't have someone to take care of the other one, you have to run somewhere, and we're all juggling a million things. Is it right, wrong? Put aside the moral part of it, but in the criminal world, why would they have filed charges against this woman? Okay, tell her this is not the right way to handle it. You know, talk to the child, talk to them, but leave it alone. But criminal charges? I mean, the standard of care had to be so grossly deviated from the typical and what a reasonable parent would have done for them to file these charges. I looked at the code section, and that's what they have to that's what they need. A reasonable person would have thought that this is so gross, such gross negligence on the part of the parent, that they would have to file this reckless endangerment charge, right? And I don't see that here. Far from it. Right?
Yeah.
Wrong. Put that aside. You file charges.
You are not going to get a lot of disagreement out of me on this. I am perplexed by this case. Now that, maybe there's some things that we don't know. I mean, I I don't know what the conditions were like, that mile distance between their house and the store. Does that mean he had to cross a highway? Does that mean it was a very dangerous part of town? I don't know. But still, I think you make an excellent point that this is kind of differences in parenting. Maybe one parent is not comfortable allowing their 10-year-old or 15-year-old to go and walk to the store alone. Maybe some people feel like they have, they just are raising their children different. They want their children to have independence, and demonstrate that. And we're not talking about some inherently, putting aside what I just said, putting aside some sort of extraordinary conditions. There's nothing illegal or inherently dangerous about walking to the store in the middle of the day. When I was a kid, we walked to and from elementary school, and that was, about half a mile of distance away from our house. No one batted an eye to see kids walking to and from, elementary school. So this is strange to me. It bothers me. So I think I'm just adding fuel to your fire here, but according to Parents USA, which is a group in support of this kind of what is being called free range parenting, the statute that was used to charge Patterson in this case was declared unconstitutional by the Georgia Supreme Court back in the 90s. Do you think this is just a demonstration of out and out prosecutorial overreach, and that this should have just been maybe something where they advised them that, the neighbors were concerned and move on with life?
Look, even without knowing what you just said about the statute, if the statute was held to be unconstitutional, why are they charging her under the statute? Clearly, her criminal defense lawyer is going to be raising that issue, right?
Yeah.
But it is an overreach. It is prosecutorial overreach. I mean, especially for someone who's in LA. I mean, aren't there better things for them to do? Aren't there more serious cases that they can go after? You're going after a mom who's really taking care of another child here, taking the other child to the doctor. So something must have come up. And we're talking about a 10-year-old. Some 10-year-olds are pretty mature and they understand the safety of crossing the street, safety issues. This doesn't seem to be somewhere that was really far. The child knew how to get to this, clearly knew how to get to the gas station, got there safely. No one's alleging that something happened in between. He was about to get hit by a car. Someone was about to kidnap this child. I haven't seen anything out there in the news media about the area being dangerous in any way. So again, I mean, this to me, I'm flabbergasted, and it's starting to become scary to be a parent. Honestly, when you see cases like this, you start wondering, oh my God, what kind of luck is this?
Yeah.
Can they come after us? Who wants to be a parent if this is what prosecutors can do?
Yeah. The other point you raised, which I thought was excellent, is that we don't know the circumstances under which she is trying to parent. There's a lot of people who may be critical of this woman and say, well, I would never leave my kids at home alone. Well, maybe she doesn't have the resources to go take one kid to the hospital, get the other kid, make sure he's got some snacks at home or whatever it is. Maybe she's doing her best to kind of hold it all together. And that might include the 10-year-old going to the dollar store on his own every once in a while. Far be it from us to assume what are the kind of financial or other circumstances this woman is dealing with. As we were speaking, it reminded me of a lesson I learned when I was a very young DA that was taught to me by a judge, where I was handling a case with a mother who had left her child in the car and gone inside of a store. And someone some patron saw the child inside of the car. Police were called. She was arrested. Very similar thing, that she had left her kid inside of this car. And she was being charged with neglect because, how could you leave your kid inside of a car? And I'll never forget this. The judge pulls me up to Mr. Ritter, could you come here? And I kind of meekly walk up to the bench. She goes, you have kids? And I go, no, I don't, Your Honor. This is many years ago. And she goes, do you know how hard it is getting your kids in and out of the car for every single stop that you make every single day? Do you know how many times every single parent has just run inside to grab something quick, and maybe they got to leave their kid in the car while it's sleeping or, whatever else is going on. And it really just kind of humbled me to the idea that, we may not understand all the circumstances.
Exactly. And even in this case, who knows? The mom probably left the child at home. He's a 10-year-old, told him, don't leave, stay here. I'm going to be gone for an hour. Take your brother and be back. And the kid walked out. So do we prosecute the mother for that? Because I also didn't see anything in any of the coverage on this case that the mom knew that he'd left.
Yeah, that's another point.
Yeah, that's something else. And again, the case that you were just mentioned, parents, and it depends on the age of the child. If is the child an infant and are the windows rolled down so there's no issues about suffocation or lack of oxygen, they're sleeping, you're going to run in quickly, come back. Again, look, parents can defer on parenting. Is that right? Is that wrong? Everybody, we all have our own style of parenting. And look, I may not allow my 15 or 16-year-old to walk a mile away. I may be worried and scared because maybe the area he's in is something that's worrisome, right? Or I don't trust my child, whatever the reasons are. But it doesn't mean that a parent who did that or allowed it should be prosecuted.
Yeah. Yeah. I'm really curious to see how this case plays out because I agree with you on everything you're saying. And I think it is setting a very scary precedent for what kind of law lines are we drawing on the sand as far as parents go.
Have you guys heard of LAL? LAL is laser-assisted lipo, and the results from LAL are incredible. I've been looking at before and afters from Sono Bello, and these women look incredible. Lipo used to be such a bad word, but we're also supposed to act like we love every part of our bodies. It's BS. You deserve to get the body you want. I've had 3 kids, and getting your body back is so hard. I get it. That's why I want you guys to check out Sono Bello. The most known secret with celebs and influencers, so many have had lipo. Whether it's a small touch-up or a total makeover, no one has the perfect body. But lipo has changed, and Sono Bello has been at the forefront with using LAL technology and getting these beautiful, natural outcomes for each person. Our friends at Sono Bello are offering you their best deal. You're now included in their Friends and Family Holiday Savings Event. You'll get the same price that Sono Bello family and friends pay, but appointments are limited, so get on this. Sono Bello doctors are masters in micro laser fat removal, a brilliant technique that removes stubborn fat permanently. Whether your problem areas are your tummy, your love handles, your thighs, your arms, it's gone in one comfortable visit. Eating healthy and workouts are great. Keep doing it. But if you want to lose that stubborn fat in one visit, check out Sono Bello. Save big during Sono Bello's Friends and Family Fall Savings Event. Schedule your free consultation now at sonobello.com/truecrime. That's sonobello.com/truecrime.
Let's jump over to Dedham, Massachusetts, where prosecutors were denied access to family phone records in the Karen Reed case as the woman charged with killing her police officer boyfriend nears a contentious retrial. Deliberations ended with a hung jury earlier this year, and now prosecutors are looking to bolster their case ahead of a second bite at the apple. Hank Brennan, who was appointed as a special prosecutor for the second go-around, sought the phone records of Reed's parents in an effort to demonstrate that a late-night call made by Reed on the night of the incident presented, quote, strong evidence that she knew she had done something terrible. While the motion was denied, prosecutors still have full access to all of Reed's personal cell phone records, reportedly plan to call Reed's father to the stand when the case reaches a jury. As the state seeks to prove their theory that Reed drunkenly hit her boyfriend John O'Keefe with her car before leaving the man to die in the snow, Reed's defense has been busy attempting to have charges thrown out ahead of trial. And now the Massachusetts Supreme Court is considering a request on Reed's behalf to dismiss charges of second-degree murder and leaving the scene of a personal injury or death. The High Court has not announced a decision on the request. However, they will have additional time to mull it over, as prosecutors in Reed's defense are seeking a delay in the trial until at least April of next year. Lara, the judge has been very conscientious of privacy concerns in this case, and using that as a reason for, in the previous trial, denying the request by the defense, several requests by the defense made for phone records of people who were inside of the home where O'Keefe's body was located. Do you think that she made the right call here? Because in my view, it's slightly different. We're talking about conversations that the defendant may have been having close in time to when they believe this alleged crime took place. What are your thoughts on the judge's decision here?
It would have also been, I mean, if we're talking about this is different versus some of the witnesses who were in the home and count conversations that they may have had, I think it's pretty close. And if he denied it for the defense, he denied the defense requests, and the defense, they're entitled to any exonerating evidence, obviously. And if there was any potentially exonerating evidence in the phone records of some of these witnesses that the defense was seeking, that would have been very important. But the court clearly denied those requests based on privacy concerns. Why not apply the same standard? What's so different about the defendant? And in reality, what is it that the prosecutor is trying to get? These are phone records, meaning I'm assuming you're only going to have a listing of phone calls and the time of the phone call and the duration of the phone call. Maybe, I don't know if they're getting cell site information, kind of figure out where the individuals were, and make some kind of kind of draw some kind of a conclusion about the evidence based on that. I don't think the judge is doing anything wrong. I don't think it's necessary for the prosecution. I feel like they're going on a fishing expedition. And look, if they can put him on and ask the questions, I mean, I'm assuming that the defense is going to say relevance at that point, but who knows what the judge is going to do. But I think, to be fair, the judge has to deny, and he did the right thing. If he denied the defense's request for similar phone records, that could have been maybe exonerating. Now, the prosecution is trying to get incriminating or inculpatory evidence. He would have to deny it on the same grounds.
Yeah, I think you're right. I think the judge, at least she felt that she was kind of cornered, having made those decisions before. Regardless of the difference this time around, you couldn't really find enough wiggle room to give herself an allowance to make a new decision.
And how often do we get judges saying, oh, privacy grounds, you're not going to get phone records? We don't, I mean, typically in LA, we don't get that, right?
Yeah.
We have phone records and we get them. We usually, they're not litigated to this extent, and we don't see judges denying them, especially if there may be some exonerating evidence. It's an issue, especially that it may be an appellate issue for the defense later. But then the prosecution, they're looking for incriminating evidence. So I don't think even they're on the same level, honestly.
Yeah. And you're right. I think the judge is thinking about, what will this look like on appeal if I give the prosecution this after I denied it to the defense, and maybe realizing she's already seen the prosecution's case, knows the strengths and weaknesses of it, and maybe is just feeling like this isn't all that big of a difference maker anyways. Which brings me to my second question here. There does seem to be a pretty dramatic shift in strategy for the Commonwealth this time around. In the initial trial, Lolly, the prosecutor, really kind of ignored a lot of Karen Reed's, I would say, perhaps behavior as far as statements made to the press, and statements that her parents made to media, and just kind of proceeded with a case of, here's the facts, here's the evidence that I have. This time around, the prosecution is asking for the unredacted videotapes of interviews made to reporters where who knows what might have been said by Karen Reed or her parents. What do you think of this? I mean, am I right to say this indicates a possible shift in strategy? And what do you think about that shift?
It's pretty clear that there is a shift. Look, the first prosecutor kind of tried to keep the case clean and limited to the facts that they're going to present, the evidence at the scene, and statements that may have been made to officers. That's what they did. And maybe that was the right strategy for them. And they felt that let's keep it focused so we're not confusing the jury by bringing all these extra things that are not necessary for the case. And maybe they're hoping that they could win without any of that, right? But then I've seen this before where a prosecutor starts with a case and then you have a mistrial. And then the second time around, they get more evidence. And then you get another mistrial. And then suddenly there's more evidence. And it's generally in the form of character assassination. That's exactly what they're doing here. It's about character assassination. They don't want her to look like this amazing person. Her persona in the media has been very positive, and public opinion has been on her side. And I think what they're going to do is they're going to take that and try and turn that around and use it against her. And but then that also gives you the signs of some desperation, right? Because if you're resorting to that, that means your case, the real evidence, is not that strong.
Yeah, could be. It could. Well, I will say they do seem, they've switched prosecutors. They've brought in this new special prosecutor. It does seem like they are taking this very seriously the next time around. I'm not saying they phoned it in the first time, but they've brought in the big guns for the second trial. But to that point of the prosecution switching strategy, the defense could also switch strategy. They're not tied to the same strategy that they were in the first case. And in the first case, they had this very aggressive yet elaborate kind of theory about a cover-up and a frame job, and the police were involved, and all of these different players were involved in this murder of this man, and to pin it on poor Karen Read. The prosecution seems to have learned a little bit of a lesson from the first time around. Do you think the defense might learn something from the fact that it was a hung jury, meaning maybe some of those jurors didn't entirely buy that defense, and they might pivot for the second time around?
Yes, it's possible. And any good criminal defense attorney is going to make an effort to speak to jurors, if allowed, obviously, by the court, to try and understand what worked and what didn't work. And I'm sure at this point they've regrouped, and some of it also is going to depend on the new evidence that's going to come in, if any new evidence comes in, including any interviews, any statements that were made to the media, the father's testimony, any questions about calls the same evening. So then we're going to have more information. Maybe but I don't see them completely pivoting away from what their initial strategy, because that's been the core of this case. Them pointing the finger at the police department, at corruption, at a cover-up, at witnesses at the home, some of the calls, some of the searches on their phone, right? How long does it take for someone to die? There was so much going on. I just don't see them completely separating themselves from that and coming up with a whole new defense. Maybe there's some nuances and tweaking here and there. I don't see a major pivot, to be honest with you.
I think you might be right too, because even putting aside the strategy of what takes place inside the four corners of that courtroom, Karen Read does seem to be very concerned with her public perception. And I think if they abandon that strategy from the first time around entirely, she knows there might be a public backlash to all of that. And maybe that's enough for her. I'm not trying to say what happened or not. I'm just saying from a PR perspective, she might not feel that that's a smart move too. So
and maybe credibility as a result. Look, that was your defense. You're pointing the finger at the police department, people who knew the decedent, issues there, cover up. Suddenly, you're just completely abandoning that. I just don't see that happening.
No. Yeah. Well, we're going to find out soon enough. It's set to go to trial early next year. I know they're pushing to push it as far as April, but I think we're going to be having an answer to some of our questions here by the first half of 2025. And we will, of course, keep everyone updated on that case. Finally, let's move to Oakland County, Michigan, where months after her conviction on multiple counts of involuntary manslaughter, the mother of the Oxford school shooter is seeking to overturn the decision with some provocative assertions. Jennifer Crumbley was sentenced to 10 to 15 years behind bars for her neglect to intervene in the actions of her son, Ethan Crumbley. Jurors found that Crumbley refused mental health care for her son amid signs of distress, allowed him access to a firearm, and refused to remove him from school on the day of the fatal shootings, despite concern from administrators. However, Crumbley's defense is now claiming that she did not receive a fair trial, arguing that two key witnesses for the prosecution entered into cooperation agreements in exchange for their testimony, and that her defense was not informed of these. The prosecutor's office has maintained that the witnesses were not granted immunity or any promises of protection, citing a previous ruling from the Michigan Court of Appeals. Whether the defense argument will carry the day remains to be seen, but we will continue to update you as any developments in this landmark case take place. Lara, explain to us why is this important? Why is the defense so up in arms about this? What is a cooperation agreement, and why is it important that that be shared with the defense?
Look, the defense has the right to be up in arms about this. You're talking about two witnesses it sounds like they were pretty key witnesses or material witnesses in the case who have cooperation agreements, which means there's some kind of an agreement. I don't know the exact nature or the extent of the cooperation, but there's some kind of an agreement between the witness or the witnesses and the prosecution that if they testify, either they won't be prosecuting them or they'll give them immunity, whatever it may be, right? But that is exonerating evidence. That's impeachment evidence that the defense could have used to attack the credibility of those two witnesses. And if they were never told about that, then the case should be overturned. I think they're within their rights. The prosecution should have turned it over. Not my understanding is that they're denying that there was an offer of immunity. But then what is this cooperation agreement? Even if there was no offer of immunity, but if there was some kind of cooperation agreement, there's a quid pro quo there, and they promised something in return for that testimony. And the defense should have been entitled to know about it. And this is a unique case, right? You're not seeing parents being prosecuted in these types of cases. Generally for lack of supervision or a case like this. We had the first case, which was a little, the prosecution had misused their discretion to file. This one is a closer one. Again, it looks like we're in this area now as parents. We really need to start worrying about how we parent our children. And we worry about every single act and decision we make as far as kids are concerned, especially a child who has some mental health issues, right? Which is what we're dealing with here. So this is a very interesting one. Yeah, but I'm hoping that the courts would agree with the defense on this one.
Yeah, it does seem like prosecutors' offices have become much more bold and kind of stretching the limits of this liability that takes place between the actions of a child and the responsibilities of a parent. And we are getting into, as much as I agree with and I applaud anyone's efforts to try to put an end to these horrible school shootings, we are getting into some very strange, uncharted, perhaps dangerous territory if we don't really think about, the further ramifications of all of this. But let's say this is true, and I agree with you. I think the prosecutor might have been a little clever with the choice of words there by saying no immunity was offered. Well, it doesn't necessarily need to be flat out immunity that you can offer to someone to still create some sort of a incentive for them to testify. Let's say that something was withheld. There was some sort of agreement between these witnesses, and that was not turned over to the defense. Do you think that's enough to actually give them a new trial, to overturn a conviction and give them the opportunity to go back to court?
I would hope so, honestly, especially if these were material witnesses. This woman is looking at 10 to 15 years, I think, in jail. It's not just a minor thing here. And yes, if these were material and key witnesses and their testimony did impact the jury, I think that this should be overturned, because if you ask me, this is prosecutorial misconduct. Why didn't they turn it over? What reason did they have? What justification do they have for not turning over this kind of information? This is pertinent information, whether immunity or something else. It is a cooperation agreement of some sort. They should have told. What was the harm in telling? If it was so not important, what was the harm in telling the defense about this? I mean, they know they've made a big mistake. And I would hope that this is something that the court will take into consideration and do the right thing. I mean, I think the conviction should be overturned. She's entitled to a new trial where her defense team and herself know everything about the witnesses, especially if if it's information that's available to the prosecutor. If it was something that was not available to the prosecutor, I'd say, you know what? It wasn't available to them. It wasn't reasonable for it to be available, but then this is an agreement that they're engaged in. It's the prosecutor talking to the witnesses. There's a cooperation agreement between the two. There's zero excuse for not turning it over. And there has to be some consequences for that. What other consequence can we have in a case like this other than overturning it?
Yeah, and as a former prosecutor, I always get a little especially offended when you see unforced errors on the part of the prosecution, because this is not something that would have made or break their case, whether or not this information was shared with the defense. And if it's laziness, that may be understandable, but still unforgivable. And if it was done on purpose, well, then it's both unforgivable and it doesn't make any sense to me, because it does create such tremendous problems. Which brings me kind of to my last question here, that because this case is kind of groundbreaking, and because it is, many people have referred to it as a first of its kind, do you think that will help or hinder the Crumbleys in their appeals process? And I know you're not an appellate expert, and I don't want to put you on the spot, but do you think in these groundbreaking cases that creates more issues on appeal?
Yeah, and I think that may help them rather than hurt them, right? Because these are groundbreaking. This is a groundbreaking case, and I think the entire nation is watching it, right? Because every parent is thinking, "Oh my goodness, who knows who can be in their shoes," right? God forbid. I mean, it's a really heinous crime. But again, is a parent responsible for the actions of his or her child? And that's a huge question, and it's not an easy one to answer, and it really depends on the circumstances, and we need to figure out where to draw the line. And this is going to be one of those cases, and I think that's going to help this family, because the courts are going to take it seriously. This is not your typical case. There's a lot at stake here.
Yeah, there is a lot at stake. It is certainly one of those cases that it seems like people are looking at it much more for its ramifications outside of the courtroom than what's actually happening in the courtroom. So many people are saying, okay, if this is true, well, then what does that mean for other parents? What does that mean, looking down the line? What conduct is considered to now be implicating parents in the actions of their children? Very interesting stuff, even from a kind of removing ourselves a degree and looking at it in a legal analysis perspective. But we will leave it there for now and continue to watch that case. In the meantime, Lara, thank you so much for coming on this week. Where can people find out more about you?
They can find me on my website at laralaw.com or yeretsianlaw.com. They can call the office at 818-741-1220. I'm a criminal defense attorney in the Los Angeles area, practicing all over, both in state and federal courts. I should be easy to find.
Good. And maybe you'll be seeing the two of us together in court sometime soon.
Maybe we will. I'm looking forward to that. But this was fun.
Good. I'm glad you enjoyed it. I am your host, Josh Ritter. You can find me on Instagram and Twitter at Joshua Ritter ESQ. And if you want to hear my thoughts and coverage on even more true crime cases, you can also check out my brand new YouTube channel, Courtroom Confidential. And of course, you can find all of our Sidebar episodes wherever you get your podcasts. And we want to hear from you. If you got questions or comments you would like us to address, please tweet us your questions with the hashtag TCN Sidebar. And thank you for joining us at the True Crime News Sidebar.